Hello, good evening, everyone, all my colleagues here at the Academy and all my friends, colleagues online. Welcome to this seminar on medical consent. As you can see from the poster, this is an event co-organized by three entities in no particular order. On the left, you can see CMEL, the Center of Medical Ethics and Law of the Hong Kong U. It's a joint organization between the medical faculty and the law faculty. Then you have the Hong Kong Academy of Medicine, of course. And then there is, on the medical side at Hong Kong U, the Medical Ethics and Humanities Unit. So three of us, we tend to sort of get together, have dinner and all the fun, plus doing the occasional events to help promote awareness and knowledge about legal and ethical issues related to medicine. So today, we are going to focus on medical consent. And I'm very, very pleased to be able to introduce our first speaker, who is Professor Rachael Mulheron. She is a professor in law, in particular tort law and civil justice, at the Queen Mary University of London. She has done a lot of work on legal reform, and her expertise is in torts and medical negligence and collective or class actions. Today, she's going to give us an update about the all-frightening Montgomery. Although many of you here are not lawyers, I'm sure many of you are aware of the importance and impact of this Supreme Court decision of Montgomery and Lanarkshire. And we have heard a lot about Montgomery in recent years, about its general ideas. But today, I think Rachael is going to talk to us the downstream ramifications of Montgomery and all the different guises and maldevelopments, if you like, that Montgomery has taken. So welcome, Rachael.
Well, good evening, everyone, and thank you very much to CML, to the Hong Kong Academy and to Hong Kong University for this very kind invitation to present to you this evening on Montgomery and Lanarkshire, 10 years on, and what a 10 years it's been. It's going to be a discussion as described of the downstream effect, the impact, more nuanced than perhaps we might have expected back in 2015. So, with respect to the topic, every procedure, every operation has inherent risks, and these are those that cannot be removed through the exercise of reasonable skill and care. The operation may be completely performed without negligence, but the allegation is that certain risks were not warned about. Now, the question for Montgomery and Lanarkshire was, what risks have to be disclosed to the patient? Now, as with a lot of important tort cases, this came down to a battle of two clear points of view. One was that the risks that need to be disclosed are what a patient would want to be told about the risks associated with the procedure. The other point of view was that what should be disclosed is what a responsible body of medical opinion thinks ought to have been disclosed to the patient. That second aspect being Bolam evidence. So this became a battle between the patient-centric type view and the Bolam view. And in Montgomery and Lanarkshire, the Supreme Court opted for the patient-centric view. Now, not quite as simple as that, as I'll go on to explain, but in order to explain this, I'm going to divide my presentation into 5 parts. First of all, I'm just going to set the context and explain the decision and its reasoning. Secondly, in part B, I'm going to explain how Bolam still applies in many respects in risk disclosure, something which must be kept in mind with respect to medical practice. The third is, I hope, a useful checklist of factors which I've elicited from the case law since Montgomery. 125 cases have been handed down since Montgomery on this issue, and I hope that the checklist will assist in assisting with what matters at the coalface. The fourth section is some best practice indicators, and lastly, a few takeaways. So moving to the first section, Montgomery was stacked with 7 members on this court because, quite frankly, before 2015, the law of England was in some disarray when it came to risk disclosure. In the famous case of Sidaway, which is 1985, the majority, led by the great tort lawyer Lord Bridge, had held that Bolam was the evidence which must be adduced as to whether a risk ought to be disclosed or not. Was the risk something that should be disclosed? Bolam evidence would dictate that. The centre said that the majority said that in Sidaway, but the dissenter, Lord Scarman, was of quite the opposite view. So immediately in Sidaway, you had this dichotomy of opinion between the majority who favoured Bolam and the dissenter who didn't, Lord Scarman. But then the next decade brought Pierce, where again an eminent lawyer, Lord Wolfe, Master of the Rolls no less, he indicated quite clearly that it was the reasonable patient test which he thought was determinative of whether risks should be disclosed. There, a stillbirth had occurred after a pregnancy went overdue by 2 weeks, and he thought that a reasonable patient test should be applied as to whether that risk of stillbirth ought to have been disclosed. Now, these two decisions, a decade apart, meant that first instance judges in England were completely unsure as to whether it was Bolam or it was the reasonable patient test. And indeed, just as Cranston said in Bircham UCL Hospital, the matter's not as straightforward as it could be. And that was an understatement. So then that's when Montgomery came to the Supreme Court, 7-member bench. Now, it was a tragic case, undoubtedly. Mrs. Montgomery, Nadine Montgomery, was a lady of small stature. It was her first-time baby, and she was a diabetic. And all through the treatment of the pregnancy, it was indicated that her baby would be on the large side. And apparently, as the doctors in the room would know, this is typical of a baby of a diabetic. And the baby was toward the end in the 95th percentile of size, a large baby. Miss Montgomery herself was concerned about having a large baby. She was aware that she was at risk of that. And she discussed it with her obstetrician gynaecologist, Dr. McClellan. And Dr. McClellan said that if a vaginal delivery, the natural vaginal delivery would be in order, but if things go wrong during the delivery, then we will switch to an emergency caesarean. And that's the tenor of their discussions throughout. Now, at no time did Dr. McClellan mention to Miss Montgomery the risk of shoulder dystoxia. And again, as the medical attendees will know, but apparently the largest part of a baby usually is its head. But with respect to a baby that's born to a diabetic mother, it's usually the shoulders. And shoulder dystoxia is caused when the head passes through, but the shoulders are stuck behind the pelvic bone. And unfortunately, that is what occurred in this case. There was a 12-minute period of pandemonium whilst the child was thought to be born. The recommendation within the theatre was changed to a caesarean, but Dr. McClellan thought that the pursuance of a natural vaginal delivery was the thing to do, and that's what happened. So the baby, Sam, was without a proper oxygen flow for some 12 minutes whilst the umbilical cord was occluded. And as a result, Sam, the baby, was born in October 1999 with severe disabilities. So Miss Montgomery's allegation was that the risk of shoulder dystoxia was not alerted to her. And the evidence was that the risk of shoulder dystoxia to a lady in her condition, small stature, first-time mother, diabetic, was between 9 and 10%, quite significant percentage. But the risk of neurological damage to a baby resulting from shoulder dystoxia and the obstetric emergency that followed was about 0.1%, much lower. Now, in this case, the Bolam evidence, which was given on behalf of Dr. McClellan and which was conceded by Ms. Montgomery's expert under cross-examination, was that the warning of shoulder dystoxia would not ordinarily be given. Why? For 2 reasons. The risk of neurological damage to the baby was considered to be very small, and that was considered across the profession to be so, 0.1 at most. 0.1%. The second reason given was that if the risk of shoulder dystoxia was averted to patients, then most mothers would elect to have a caesarean. An elective caesarean would be their choice. And Dr. McClellan thought that that itself carries risks to the mother. And the Bolam evidence, as I say, both her own expert and Miss Montgomery's expert under cross-examination conceded that. So the Bolam evidence on both sides indicated this risk should not have been disclosed, but the Supreme Court held it should have been. So this was a groundbreaking case because the Supreme Court considered that this was not Bolam-centric any longer, this issue, the reasonable patient test applied. Now, in respect of the duty, what is the doctor's duty re-disclosure of risks? So the judgment, which was written by Lord Kerr and Lord Reid, says this, that the duty is a duty to take reasonable care to ensure that the patient is aware of any material risks involved in any recommended treatment and of any reasonable alternative or variant treatments. The test of materiality, i.e. what should be disclosed, is whether in the circumstances of the particular case a reasonable person in the patient's position would be likely to attach significance to the risk, or the doctor is or should reasonably be aware that the particular patient would be likely to attach significance to the risk. So you have two limbs here. You have the reasonable patient, what would they want to be informed about? And then you've got that particular patient subjectively, what would that patient want to be warned about? It's a two-limb test drawn from paragraph 87. Now, that's really the ratio of Montgomery, but then the court went on to say that it's not just the magnitude of percentages which matter. It was said that the assessment of whether the risk is material cannot be reduced to percentages. The significance of a given risk is likely to reflect a variety of factors besides the magnitude, such as the nature of the risk, the effect which its occurrence would have on the life of the patient, the importance to the patient of the benefits sought by the treatment, the alternatives available and the risk involved in those alternatives. It's very fact sensitive. Now that is, of course, the issue. What factors do indicate that under this test developed on the previous slide, the reasonable patient or that particular patient, what factors indicate now, 10 years on, that a risk should be disclosed? And that's what I hope to be able to shed some light on in this talk. Now, just in terms of setting the context, just to finish off, the Montgomery decision itself has been followed in 2023 by McCulloch. And I think now that the disclosure of risks in England and Wales is governed by the package, which is Montgomery plus McCulloch. McCulloch is a very important decision because it rolls back Montgomery slightly. And it's very important to understand that when understanding Montgomery as it applies 10 years on. I also mentioned that Australian jurisprudence, which is of course only persuasive in England, it is actually of some interest because in Montgomery in 2015, the Supreme Court explicitly referred to and adopted the test of materiality from Rogers and Whittaker, a famous case in Australia, 1992, famous case where Miss Whittaker was an English-born lady and she suffered an eye injury when she was a child, 9 years old. She had a penetrative injury from falling on a metal railing. And she lost vision in the eye. She emigrated to Australia. She lived a full and happy life. She married. She had a job. And it was suggested to her that ophthalmic surgery had progressed to the point where she could perhaps have the sight restored in that eye. So she underwent the surgery. And the surgery was perfectly competently performed. No question of any negligence. But prior to the operation, she was so concerned about the good eye, the one good eye, and she said, nothing's going to happen to it. The scalpel's not going to slip, is it? And she was reassured that there'd be cotton wool pads placed upon it. Nothing like that would happen. But the worst happened after the event. The good eye turned in sympathy with the bad eye, and she suffered this condition called sympathetic ophthalmia. Apparently at the time, 1 in 14,000 risk, so rare, hardly referred to in textbooks in Australia. But it happened. She argued she should have been warned about it, and the High Court agreed on this newly developed test that they developed of reasonable patient or that particular patient. She did not want to lose vision as a result of this surgery. So the Australian literature and the case law is actually quite persuasively significant for England, and I'll come back to that. Also, just mention Lord Reid, when he gave his speech, The Immortal Snail, on the 90th anniversary of Donoghue and Stevenson, he happened to mention that in Montgomery, the court did exactly what it did in Donoghue and Stevenson. Way back then in 1932, the House of Lords then looked over to the United States, to the decision of Macpherson and Buick, which was a 1916 decision where the New York Supreme Court had allowed a duty of care in the absence of privity of contract. And he said, we followed that idea in Donoghue and Stevenson. And similarly here, we're drawing from other common law jurisdictions. It just shows, I think, the enormous cross-fertilisation of the common law around the world. So moving on then, to the second part, how does Bolam still apply? And it does. Now, just to get rid of that, in relation to the way in which the Montgomery plus McCulloch package works, the doctors amongst you may think this is entirely unrealistic, and many would agree with you in England. But the way in which it's being analysed in England by virtue of these two Supreme Court decisions is that there's a 5-step process in the risk disclosure issue. The first is that there has to be a diagnosis. Now, whether the diagnosis was correctly done has always been the subject of Bolam evidence in England. It's always been subject to whether peer professional opinion considered that diagnosis to be a reasonable one and qualified by the Bolitho gloss. Was that peer professional opinion logical, rational, and articulately explained? So in that respect, Bolam applies to the stage 1, always has. But then, moving on, this is where McCulloch becomes important, 2023. Once there's a diagnosis, treatment options must be put to the patient. Now, with respect to those alternative treatment options that must be explained to the patient, what risks are associated with each of those treatment options, what are known risks, is solely Bolam determinated. That's a matter for clinical judgment. The court will defer to the clinical judgment adduced at court as to what risks should have been known about. And that was the point in Juice. The risk resulting from a hysterectomy was not known about in 2008, and that was solely a matter of clinical judgment that it wasn't known about. No negligence in not disclosing. But having then determined what treatment options are available, then the doctor's responsibility, according to McCulloch, is to put to the patient those which are reasonable, to omit those which are possible but not reasonable, and only put to the patient those that are reasonable. Now, which are put to the patient as alternative treatment options? Bolam, again, decides that. Not Montgomery, Bolam. Clinical judgment decides that. And that was the point of the McCulloch case. A very sad case where Mr. McCulloch at 42 died at 39 of cardiac arrest. He'd been hospitalised twice for chest pains and he'd been sent home and he died in the second hospitalisation stint. And apparently he didn't present with symptoms of pericarditis, and his cardiologist did not think that NSAIDs were in order because he didn't present with those symptoms. So the allegation here was that the alternative treatment of NSAIDs ought to have been given to him in addition to the antibiotic treatment he was having. And the cardiologist was excused from making the alternative treatment available because on clinical judgment per Bolam, that was not a reasonable alternative to have provided. He wasn't showing those symptoms. So again, Bolam decides this, and I emphasise this because when preparing or defending cases, one has to be very cognizant of when Bolam is going to decide the issue, not the reasonable patient. When is Bolam going to be the clinching factor? So in relation to the contrasting outcomes that I've just mentioned in the cases of Bilal and Mills, with respect to poor Mr. Mr. Malik was actually the claimant in Bilal. He'd had terrible back pain for a long time, and he ended up having a surgery between the 10th and 11th vertebrae, apparently, and it didn't work out very well. And he complained that there were alternative treatments, analgesics, nerve root injections. Things should have been presented to me as an alternative. And the court there said, no, there were alternatives, but they weren't reasonable. Compare with Mr. Mills, who had a brain tumour, and there was an attempt to resection it through non-invasive endoscopy-related procedure, which was a very, very small gap and where there wasn't quite the visibility of the resectioning. And again, he said there ought to have been made plain to me there was an alternative treatment, an open resectioning, which would have allowed a microscope to have better visibility. And the court in that case said, yes, there was a reasonable alternative treatment that ought to have been provided, or at least disclosed to you. But both of those cases turned on Bolam, not what a reasonable patient would think, Bolam. And it's really important to remember that Bolam still rules in much of this area. But then we go to step 3, the risks associated with these alternative treatments, the risks associated with them. That's when Montgomery kicks in. That's when a reasonable patient test applies. What would a reasonable patient want to be told, or what would that particular patient want to be told? But Bolam is still not irrelevant. The Montgomery court itself admitted that, and indeed, I'm drawing this from paragraph 83, that what a reasonable patient wants to know is not a matter of purely professional judgment. And this absolutely replicates, and no doubt the Supreme Court was well aware of it, that the Rogers and Whittaker line of jurisprudence post-1992 in Australia absolutely came to show that Bolam was a factor as to whether a reasonable patient would want to be told or not. And that may sound inconsistent, but the court has the right to have regard to expert opinion as to what ought to have been disclosed. It's a factor, not by any means determinative, it can't be, but it is a factor. And again, very important to remember that in Mills and Oxford, the brain tumour case, the court made the point, the fact that the experts agreed that a risk should be disclosed is, to me, completely significant. That was the judge's statement. So when preparing these cases or trying to defend these cases, Bolam evidence is still not irrelevant when it comes to what risk should have been disclosed. It's not determinative, it can't be. But don't regard it as being irrelevant, because the law is showing 10 years on that it's not. Then risks that don't need to be disclosed. Again, Bolam is there in the mix, because the first category the risks that don't need to be disclosed are those that could harm the patient adversely if they are disclosed. That giving the disclosure to the patient would cause physical or mental harm, or may cause the patient to forego treatment. That the ability to withhold risk information is therapeutic privilege. And in paragraph 85 of Montgomery, the court says Bolam clinical judgment will determine that. So Bolam is again back in the frame. And the other occasions where the patient doesn't need to be informed, that is where they don't want to know, or where they are unconscious and unable to give consent, those are factual determinations. But you see, the 4 steps we've discussed so far, Bolam either determines or is not irrelevant. We then get to the 5th stage. What if the patient asks questions? Now, this is quite clear from Montgomery. Bolam has no part to play here. If the patient wants to know something, the doctor has to give an honest and truthful answer, and that is determined by the reasonable patient test. Bolam has nothing to say about that, and that is the only one of the 5 steps I've covered where Bolam is truly irrelevant. What if the patient doesn't ask the right question? And after all, poor Miss Montgomery didn't. She was concerned about a large baby. She was concerned about her small stature. She was a first-time mother. She was worried, but she didn't ask, could the baby be stuck in the birth canal during an ordinary natural delivery? She didn't ask that. And the court undoubtedly in Montgomery has taken a fairly sympathetic view to that. This risk ought to have been disclosed because she was indicating her nervousness about the conditions and the mechanics of the delivery of the child. And so even though she didn't ask the right question, she should have been told. And that, of course, comes under the second limb of Montgomery. That is what that particular patient ought to have been told. So in that respect, these 5 steps, I hope, have shown you that although Montgomery applies the reasonable patient test for risks disclosure, and it's true that what a reasonable patient or that particular patient would want to be told is determinative for risks disclosure, either side of that process in the medical diagnostics sort of the stratagem, Bolam has an enormously important part to play. And so those legal advisors preparing these cases and these doctors defending these cases must go to court having that evidence. It's absolutely crucial because it hasn't disappeared from view by any means, Bolam, not by any means. Now, moving on then to the third section of my presentation, and this is whether a risk is material. Now, a first point is to note is that I've mentioned the two limbs, what a reasonable patient would want to know and what that particular patient would want to know. These are being conflated. There is no clear distinction between them in English law. The judge simply decides, would a reasonable patient want to know this particular risk? That's it. There's no attempt to divide these, as there was post-Rogers and Whittaker in Australia. So what I've done from the 125 cases post-Montgomery in 2015 is develop this checklist of factors as to what has shown a court that a risk should be disclosed. Now, some of these might be very self-evident and some of them perhaps not so much. But I hope that this checklist would assist when a doctor is at the coalface and having to deal with a patient as to whether a risk associated with a procedure should be disclosed or not. Now, the patient's employment is very important. In Witherbottom, the lady was a speech therapist and she had a wisdom tooth extracted and wasn't warned of lingual nerve damage. The court said she should have been. She's a speech therapist. Her career evaporated after she was left with numbness and pain in her tongue and mouth. She should have been warned about it. Employment matters. Statistics don't determine the issue, but they do matter. Montgomery shows that 9 to 10% at a very high risk, said Lord Reid and Lord Kerr, it should have been disclosed. And Norney and Watt, again, very reminiscent of that in 2024. Whether the patient has a fairly patchy attitude toward medical treatment and the adherence to instructions matters. It comes back to that particular patient, but it matters. If the doctor can ascertain or knows whether the patient is diligently following instructions or is rather laissez-faire about it, that matters, because if they're laissez-faire, then the risk is greater for them, as it showed for poor Miss Thorpe, who died at age 42 from a stroke. She had not been diligent about blood pressure monitoring. So in that respect, that was an elevated risk for her, and the court found against the doctor there. With respect to the patient's own medical experiences, so if the patient, like Miss McNabb, had had sepsis previously with a post-operatively, then the fact that she may develop and did develop sepsis post-operation in this case of 2020 mattered. And the previous experience of the patient concerned matters to what risks ought to be disclosed. That's quite clear. The degree of the patient's inconvenience or pain, if they are in great pain or inconvenience, as Ms. Bigadiki was with respect to urinary incontinence, then a procedure which might exacerbate or even cause further incontinence was a risk that should have been disclosed to her. That matters. The patient's ability to better understand risks. Miss Negus was a theatre nurse, and the risk of a smaller aortic valve being used for her compared with a larger 19mm valve. The fact that she wasn't warned of the risks associated with a smaller valve mattered, because she, as a theatre nurse, could understand those risks better. So again, the fact she had that experience mattered to that court. With respect to the elective nature of the procedure, this has always been the case in English law. The more elective it is, then the greater the risks disclosure is required. Chester Navshar was approved in the Supreme Court in Montgomery. With respect to whether the treatment's very innovative, as it was in Mills, the brain tumour case, the risks were indeed not even known according to the evidence that was given to court. The more innovative the treatment, the greater the pressure on the doctor to explain the risks, or if the risks are not known, then to articulate that. It's absolutely paramount, particularly in emerging technologies with medicine. The physical attributes of the patient matter. Remember, Miss Montgomery was small in stature, and in that respect, it was a particular risk to her, the birth of a large baby born of her as a diabetic small lady. With respect to the size or the gravity of the harm, Montgomery again makes the point, the consequence for Sam, who was born in a grievously disabled state, the gravity of that harm makes the risk more necessary to disclose according to a reasonable patient. And that, I'm sure, would be common sense and indeed referred to in the judgment, but Montgomery shows that. one also has to detect how risk averse the patient is. Mr. Mills apparently hated the idea of a blood test for the risks that it might pose. So in that respect, the asking some questions of the patient to ascertain whether how risk averse they are could matter. It did matter in Mills. He would never have agreed to this innovative endoscopically related invasion for the resection. Personal matters also matter. So in Ms. Diamond's case, she was undergoing a mesh treatment for a hernia. She was not told that could compromise her ability to have children in the future. That mattered to her enormously, and it should have been disclosed. So family or personal circumstances, particularly to do with fertility, do matter. And then just a few others to mention, courtesy of the Australian jurisprudence. Any cultural concerns, anything that might mean that for that particular woman, say, infertility would make a huge difference to the way in which she is perceived by her family. Any idiosyncratic or anxiety beliefs held by that particular patient do have to be addressed when it comes to risk disclosure. And any background or history of the patient that would show a particular risk to be manifest. In Henderson and Lau, the gentleman had been subject to very serious sexual abuse as a child, and hence any risk that would make him impotent was something that was incredibly appalling to him. And so in that respect, the history and background of the patient matter. Now, that has been a list of 15 things, and I think that if doctors had something like that as a checklist, just to check off whether these things mattered on this particular patient, I would hope it would make one Montgomery compliant, because these are the factors that the cases themselves are showing up to be important. So if a doctor is shown to have addressed their mind to these during the consultation, then this is the defence, that this is what cases show to be important and this is what I've addressed. So with respect to the conclusion of this part, the case law does give real guidance and no clear demarcation between the two limbs, and I think a checklist approach to this could really help at the medical coalface, because that's where the help is needed. Now, just a final couple of best practice indicators. The English courts have made it very plain, don't assume too much about the patient's knowledge. For example, the doctor said in Winterbottom, the speech therapist case where the lingual nerve was damaged, the doctor said, but she was a speech therapist, I would have assumed that she knew about nerve damage in the mouth. And the court said, no, don't assume the patient's knowledge in that regard, an important point. Guidance notes and pamphlets and literature should be given to the patient well in advance. That has helped doctors in fighting off Montgomery cases in England. But as Justice Green said, as he then was in Thurfelt and Johnson, avoid the mutual momentum towards surgery that happens toward the end. Have these guidance pamphlets and explaining the risks in writing, have them available well before. If that is done, that is a further best practice indicator, and it has helped in English law to defeat Montgomery-type allegations. Consent forms do need explaining. One can't simply give it to the patient and simply ask them to sign it. They do need de-jargonising, according to Deacon Stevenson. That point has been emphasised a lot. Credibility disputes between the patient and the doctor are rife in English case law. The doctor didn't say that, and the doctor says, well, I would have said it, because there's no contemporaneous documents, and the English courts keep emphasising, do fill out the consent forms, do fill out the anaesthetic record sheets, do make, even if it's rough, just make some contemporaneous note of what has been discussed. It really helps when years down the track you're having a dispute about what was said or wasn't said. But beware of information overload too. I mean, the doctor has to walk a very fine line, absolutely understand, but in Montgomery it was said the advisory role involves dialogue, and this role will only be performed effectively if the information is comprehensible. So it's not therefore fulfilled by bombarding the patient with technical information which cannot be expected to be grasped. But I've just mentioned the last little point about best practice. I think that case law, which we haven't seen yet, is going to arise in relation to algorithmic therapy and treatment, because where algorithmic treatment plans are being developed, there is underneath that algorithmic treatment plan and a host of information, such as data sets, such as assumptions, such as the degree of confidence that that treatment will work for that particular patient, all of which the patient is unaware of. And that is typical, that's just the nature of algorithmic treatment plans. And I think, as was indicated by Groden Barons back in 2020, I think we've yet to see this case law in England, but I think we're going to see it. What degree of disclosure needs to be given when algorithmic treatment is at issue? One for the future. I'm sure courts will have to grapple with that. So, some key takeaways. When Lady Hale gave her speech, Legal Aid at 70, the 70th anniversary of Legal Aid in England in 2019, she admitted that Montgomery has no doubt caused practical problems. Well, it has, to the extent that the landscape has changed from Bolam to Montgomery just on that point as to what risks should be disclosed. And yes, in Thorpe and Meta, it was said by the court that Montgomery marks at least the most recent resting point on a long journey away from a predominantly paternalistic approach to the relationship between doctor and patient. Yes, that's true. But in response to Lady Hale's concerns, I would say that these three things really matter. Doctors and lawyers need to know when Bolam applies and when it cannot. And remember, Bolam applies to quite an extent in that diagnostic treatment timeline. So both the legal teams and the doctors themselves, I think, need to have a very clear understanding of when Bolam will carry the day and when it cannot. Secondly, I think a checklist of factors to determine whether a risk is material is really important, because it behoves, I think, the legal profession to make available to the medical profession the consequences of Montgomery. And that is Bolam is no longer able to be relied upon exclusively. But what are we dealing with? So I think the checklist of factors that I've gone through with you, I think, if a doctor referred to those and showed that they'd turn their minds to that, then that would, I hope, be Montgomery compliant, because that's what the case law says is relevant. And then finally, best practice guidelines do involve the good provision of guidelines well ahead, de-jargonising, and that contemporaneity of documentation. It really helps with respect to complying with Montgomery. So I hope that you found those 5 sections useful. I think we're in a very, very new, nuanced world post-Montgomery, but I hope that that will be helpful to you going forward. Thank you.